Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, Board-Certified Creditors Rights attorney Nicholas D. Krawec discusses motion for summary judgment.
Motions for summary judgment are probably not very well understood by a lot of plaintiffs in litigation. Obviously, a suit has been filed and the defendant has filed an answer raising some factual issues. I have many clients come to me and tell me, well, these allegations, they're simply false. That's not what happened. We have a number of witnesses that can refute everything this defendant is saying in his answer. Can't we move for summary judgment on this? Because this is simply just wrong. My short answer to that question is no. False statements, or perhaps more accurately, inaccurate statements, or the ability of the plaintiff to produce witnesses to rebut those statements, do not give rise to a basis for an immediate motion for summary judgment. You've got to think about the standard for summary judgment. A motion for summary judgment is a legal so what, meaning even if everything the opposing party claims is true, so what? Even admitting the facts stated by the opposing party, we are still entitled to summary judgment as a matter of law for the relief that we have requested, because there are no real genuine issues as to any material fact, and we are entitled to judgment as a matter of law. Now, the example I gave at the outset of this discussion, inaccurate allegations made by the defendant, witnesses being available to refute, that's a determination as a matter of fact, which requires a trial. Hopefully, in a trial, the trier of fact, whether that trier of fact is a judge alone or a jury, believes your witnesses and disbelieves the defendant or the defendant's witnesses. But a motion for summary judgment is a determination by the judge as a matter of law that you're entitled to the relief you requested without the need of going through the time or the expense of a trial. Now, how is a basis for summary judgment determined? Well, the first thing your attorney should look at, and you should look at when the attorney reports to you about the answer that is filed to the lawsuit, is what admissions have been made by the defendant in the answer that was filed. These admissions, where the defendant responds to your claims, they establish facts that are not in dispute. Secondly, you have to take a look at the defendant's affirmative defenses that are being alleged, and is there a need to refute them as a matter of law? Third, and probably most important from a summary judgment standpoint, is you're going to have to engage in pretrial discovery, which is another topic that's in one of our legal master presentations. You can make effective use of written discovery, such as requests for admissions, to have the defendant admit to the truth of certain facts. If the defendant denies certain facts, you can follow that up with interrogatories and say, if you denied that request for admission, tell us what you claim the facts to be. Perhaps most effective in trying to set a matter up for a motion for summary judgment is to take the deposition of the defendant and grill the defendant, question the defendant intensely about the defenses that he's asserting or the allegations that he's made in the counterclaim, and hopefully through that testimony establish that there really is no factual dispute. Once you establish there's no factual dispute based on the written discovery and the admissions you've been able to obtain, only then can a motion for summary judgment be sought. Now, you can move for summary judgment, obviously, for the claim that is set forth in your complaint. You can move for summary judgment as to the defendant's counterclaim. If the defendant has determined that he's going to try to file a counterclaim to try to get some leverage against you, file a motion for summary judgment as to both, but keep in mind a key thing, that if the defendant filed a counterclaim as a means of trying to intimidate you or leverage a mutual dismissal out of you, and you're able to get summary judgment dismissing his counterclaim, he's lost a lot of leverage. All right. The other thing that you can use the summary judgment process for is to limit the issues for trial. Sometimes summary judgment may not be rendered for all the relief that you have requested. That's often referred to as a partial summary judgment. Perhaps you may be able to have obtained summary judgment as to liability, and the trial is limited only to the amount of damages. Or the judge can enter an order setting forth the facts which are no longer genuinely disputed as a result of the admissions in the answer and the information developed through discovery. But summary judgment, as you can see, is not an easy process. All the opposing party has to do is show that there's a genuine issue of fact for trial, and you can try to overcome that through appropriate use of discovery, whether it's written or depositions. Thank you very much.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.